Just checking to see if y'all can hear me in the agenda room.
Yes, by the agenda room, do you mean 242 next door?
Running a little late. My sweet daughter had her stepping up ceremony where she has graduated from elementary school and is now going to middle school. And it was a big to-do. And she walked across the faux stage and took her diploma. And my son had his graduation ceremony where he graduated middle school and is going to high school. And they gave him his little certificate. And I took pictures and a video and told the head of school, no takesy backsies, like you've got him for the next 4 years, because middle school is a brutal experience for parents. So I'm hoping, fingers crossed, that high school will be a little bit more gentle. Honestly, the 89th legislative session is nothing compared to 8th grade in Austin, Texas, with a very hormonal, stinky boy. So thank y'all for waiting. And now we're waiting on tech still. She can hear?
I believe that Commissioner Gonzalez can hear now.
Katarina?
Yes, I can hear y'all now.
Ah,
Hooray.
perfect. Can,
Yay.
Bobby, do you know if the participants can hear?
I'll rely on them to let us know if they can continue to have difficulties, but let's proceed.
All right. Yes, Patrick, I know my mic is live. Thank you. Good morning and welcome to the May 22nd, 2025 meeting of the Texas Commission on Environmental Quality. It is 9:38 a.m. I'm joined by my colleagues, Bobby Janeka and Katarina Gonzalez. On the interwebs, our General Counsel, Mary Smith, and our Public Counsel, Garrett Arthur. For each item that argument or discussion is allowed, we will inform the parties and the public of time limits for their discussion. Registration closed at 9:30 a.m., but if you'd like to address the commission on a particular item, please either refer to our registration table if you're here in person, or if you're on the webinar, email agenda@tcaq.texas.gov with your name, affiliation, and the item you'd like to comment on, and we will do our best to accommodate you. For those making presentations, please wait to begin your presentation until I've asked you to begin speaking. And please, please, please check to see if your line is unmuted before proceeding. Anyways, Mary, first item, please.
The first item is old business 1. It's the consideration of the petition filed by OP3ATX Georgetown 2220 LP for the creation of Williamson County Municipal Utility District Number 60. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
All right, let's return to this item. Old business number 1 is a petition to create a MUD, a municipal utility district with road powers. Williamson County is the sole hearing requester. At the May 1st agenda, Commissioner Gonzalez had questions for the sole hearing requester in this matter, Williamson County, which they were unfortunately unable to answer. So this item was continued to allow the county to send a representative to answer these questions. With that, I'll ask the county's representative to approach so they can answer Commissioner Gonzalez's questions. After that, I'll give the petitioner, ED, and OPIC an opportunity to respond.
Good morning. I'm Stephanie Albright with Bickerstaff Heath Delgado Acosta, and I'm here on behalf of Williamson County.
Good morning.
Good morning.
Go ahead.
I'm here to answer any questions that you might have. I understand that Commissioner Gonzalez had some questions, and I'm happy to answer any.
Commissioner Gonzalez?
Yes, thank you. Ms. Albright, what kind of relief is the county seeking here?
What kind of relief? The county is protesting the creation of the MUD. It's actually seeking party status to have this, the MUD petition referred to SOA for a hearing. And in that hearing, there is, criteria under 54.021 of the Texas Water Code that a MUD has to meet to show that it's feasible, practical, and is necessary for, and would benefit the land. And so there's factors that we would go into in that hearing itself to discuss whether or not the MUD should be created. And for the purposes of this, the matter that's up today, it's to establish party status of Williamson County as an affected party.
Well, I understand that, but to what end? Specifically, like, are there proposed adjustments to the petition that would satisfy your concerns?
There can be. I think when we get into the hearing process, we always hire experts that then we look at the cost to figure out if the costs are reasonable. Sometimes there can be adjustments made. Sometimes there have been situations where we found that the MUD is not reasonable and is not practical or is not feasible, and have identified those factors that in the petition have not been met, and then bring those to the commission for the commission to make a decision on. And there have been situations where we have discovered, information within the applicant's information that would not support creation of the MUD.
Is that not a process, though, that also takes place within the agency?
It does, but the agency primarily relies on the preliminary engineering report and the information that's submitted from the applicant. Sometimes the experts, when we have engineers that they come in with engineering expertise that actually bring in applying sort of, information that they have in their expertise, also information that they have as a part of their business to show that the costs are unreasonable. So I think that the TCQ staff does a good job of reviewing what's submitted, that it's complete, but they don't necessarily go through a rigorous process to show that, for example, cost is the example I'm using to show that costs themselves are reasonable. We've also found in some situations that there is application information that's not complete, that it's not something that would be evident from the application materials, but when we go through the process of having experts and going through discovery, we find out that, for example, the person that applied may not be the actual owner of the property.
Mm-hmm. Trying to understand here, my understanding was your specific hearing request was based more on your statutory authority, the road powers, rather than the financial feasibility of the district. Is that incorrect?
At this point, there's a different standard to show that you're an affected person to be able to challenge the petition, which is what's before the commission now. And then once the county has party status as an affected person, then you would go into the factors under 54.021. So at this point in the process, it's not necessarily talking about whether the MUD is feasible at this point. It's talking about whether the county has standing to be able to challenge the MUD creation.
Okay. I'm still not clear, though, about what your specific concerns are with this creation? It seems to me like what you're saying is, well, we're going to go to the process and then we'll see.
And I think sometimes, part of that is finding some of the specific concerns. Some of that is part of the hearing process itself. Again, when the county would engage experts to be able to make that determination to figure out the feasibility. I think the county is relying on its statutory powers to show that how it's affected different than the general public, to be able to have party status, to be able to petition or be able to protest this petition. And I think in the county's comment letter, it specifically did raise concerns relating to the road powers and how the road powers are granted, but it also does rely on its statutory powers to be able to show that it is an affected person.
But as far as the road powers go as well, I'm trying to understand here. The county would still have to approve those road specifications, right? And the roads that would go in. So how does the SOA process impact your road powers?
So the county does, the roads would have to be built with county standards, but when you grant road powers, it doesn't grant any responsibilities or requirements relating to maintenance. I think as a part of the county's hearing request, that is in addition to its arguments that it has party status as an affected person, the county's also requested that if we get through this process and the commission does grant the MUD, that the commission include a provision in there that the MUD will be required to maintain the roads. Because even then the application, there is the intent right now in the plan that the roads internal to the subdivision will be maintained by the MUD, eventually the developer and then the MUD. But there's nothing that requires that. And sometimes you can get in situations where you have financing issues with the MUD, or you have a MUD board that just doesn't want to maintain the roads, and then they would seek to transfer those roads to the county. And that's where the county has run into concerns with the financial burden of having to maintain these internal roads.
I'm a little skeptical of that argument, given that most of these are financially feasible for you. It's part of the whole process that where we vet these. We're talking about a 30-year process at least. The MUD is responsible for maintenance during that time. And then I don't think there's any obligation of the county during that time to take the MUD. Is that an incorrect understanding?
Not to take the MUD, but I think that there's a lot of times an obligation, not necessarily a legal obligation, but it's a responsibility the counties often feel towards its citizens, that you have roads. If you have someone that's not able to maintain those roads, from a public health and safety issue, if the MUD is not prepared to maintain those roads, a county will often feel a need to have to take them over to make sure that they're maintained for the safety of its citizens.
Could you point me to a time where Williamson County has specifically had to take over maintenance of roads for a MUD?
I mean, Williamson County maintains a lot of roads on behalf of MUDs.
Yeah, that wasn't my question. A time where they had to take over specifically road maintenance from a MUD. That would be a question that, I would have to ask the county specifically. I know that they have like many subdivision roads that they maintain. And I know that as they cite in their letter, that they are, kind of suffering under that financial burden of having these roads. I don't know if there's any situation where it's gotten into like a dire situation. That I don't know specifically. Okay. Well, I mean, that is your argument though, that they would have to, there might be a situation, and that's where your powers are really impacted.
I think the issue is the overall financial obligation that the county is seeing with maintaining these internal roads, and what it's seeking in its development agreements, where most of the time they're able to mediate agreements to be able to build these developments. And the county requires that there's a provision in these agreements where the MUD agrees that, or the developer agrees that the MUD will maintain the roads. And what the county is stating is not necessarily a specific example, but its overall financial burden that it's experiencing right now, and asking that for MUDs that are created in front of the commission, that those MUDs also have a requirement to maintain the roads as it's dealing with locally. But again, that's an argument outside of its argument about party status.
Mm-hmm. Can you discuss for me for a minute how you see the proposed mud impacting your statutory authority?
I think the statutory authority, as the MUD cites in its letter, one of the things is, transportation issues overall of the roads outside the subdivision when you build a new subdivision, and they rely on not just their internal roads, but they use the roads that are already existing. They also cite emergency services, which is something that's very important, which is not just the medical, but also with police protection. When you put new subdivisions inside a county, you sort of stretch some already, some services are already stretched then. They're negatively impacted. And I think, again, those are probably the two largest. And I think the county in its letter cited, general authority that when you build something in the county's incorporated area, there's an expectation that the county is going to have the services to be able to serve those new residents that are in there. And sometimes that creates a burden on the county.
Yeah, when MUDs are created, though, aren't they required to either provide safety services or contract with y'all for those?
Not necessarily. I think it's something that
It's not one or the other?
Hmm?
It's not one or the other?
That is typically what they do. But at the same time, it doesn't mean that there's always the ability to do that. And it doesn't mean that a county is necessarily going to have the capacity to provide those services, but that would come after the development is built. And that would be a decision of either the MUD or the developer at the time and the county.
I mean, my understanding of this is that they either have to contract with someone for it or contract with you.
I mean, typically that's what's done.
Yes, okay. So just to reiterate here, does this creation of the MUD, does that change the responsibility for complying with county specifications for drainage and road improvements at all?
Not for road improvements, that they will have to meet county standards for road improvements and the initial construction. And typically they would follow the county drainage rules, but sometimes that really depends on the county as to what rules they have in meeting drainage.
Well, we're talking about Williamson County.
Williamson County, and yes, they would have to meet whatever the county standards are.
Okay. And the proposed MUD, if granted, would still have to go through your process for platting and road construction and meet those standards required by the county, correct?
That's correct.
And all other county requirements?
Any that are applicable.
Okay. All right, I think we maybe just see this differently, but that's my questions. Thank you.
Thank you.
Commissioner Janeka, do you have any questions for Ms. Albright?
Well, I was curious to know, particularly given that we've repeated this exercise a few times with different matters, but limited ourselves here, was if there were an assurance or a guarantee associated with the permit, and I'm not sure what the executive director's ability to allow for this in our process might allow, but certainly within our ADR, alternative dispute and resolution pathway, I would imagine there is some scenario where that's a quick exit to avoid SOA and the lengthy delay. And I would, in light of that opportunity, I would really consider repeat where that's a clear, discrete need from the county's responsibilities on these creations. I hope that it doesn't begin to look like gamesmanship in terms of just extending the length of time that remains between final creation and initiation of these different projects. I appreciate Commissioner Gonzalez's interest in this, and I think it has highlighted that there should be, given the times we've seen repeat requests come before us, there should be some better informed action in the different parties. So I hope that we're able to take opportunities to utilize ADR and tools like that.
Absolutely. And I will say on behalf of Williamson County, I think, again, the provisions that it cites in its letter is a part of its development agreement that it typically uses with these MUDs that are coming in. And I know for the entity right here that we're talking about today, they are in discussions. But once they push the petition, I mean, we have statutory deadlines, and here, we have to the county has to establish it's an effective party. So if those conversations do fail, that it's preserved its rights under the law to be able to protest the application. But yes, there's always always the hope, and I would say that we've had a very great experience with TCQ's ADR staff that have been really helpful in these processes.
Thank you. Pleased to hear that.
Thank you.
Thank you, Ms. Albright. I believe we have a Mr. John Scott here for the MUD petitioner. Would you like to address the commission?
Congratulations on at least 2 out of the 3 of y'all's passage.
Thank you, John.
Does that work? Whoa. I'm here on behalf of OP3 ATX Georgetown 220 LP, catchy name. We have sought an administrative MUD, creation of a MUD. We have been responded on the last day of the comment period by Williamson County. At that time, they asserted a number of things. Most of the relevant ones, the drainage issues, the roads, those were all things that they control through their internal process. We have to comply with that. We do not dispute that. What we've been receiving from them is a proposed development agreement that includes maintenance of the roadways in perpetuity. It includes right-of-way authority. And most recently, they've asked that we do away with our vesting rights. So it continues to grow and grow and grow. All these are non-justiciable over here. I mean, these are not issues that are at the heart of what the MUD is created for. This is something when you go through the legislature, and Williamson County is one of the MUDs, they try and extract from you over there. And extract's the kindest word I can use. Many would say extort, because they perpetrate this idea that we're going to put you into SOA and develop an 18-month delay at a minimum. And that puts developers in a bind from the get-go. So from our standpoint, we do not believe there's a justiciable issue. And we think the referral of them to SOA on this issue is incorrect. Happy to answer any questions.
Commissioner Gonzalez, any questions for Mr. Scott?
Mr. Scott, I'm trying to understand too, the feasibility process that y'all go through. Is there anything that would change about that through the SOA process?
No, ma'am.
Okay, thank you.
Commissioner Janeka, anything for Mr. Scott? No. Thank you, Mr. Scott. I believe we have the Executive Director, Kayla Murray. Any questions for Kayla? Katarina?
I would be interested in the ED's take on this as to whether there is a justiciable issue that would result from the SOA process.
Kayla Murray for the Executive Director. Not quite sure if I fully understand your question. The county would be responsible for, as you stated earlier, for the road maintenance, as long as it's in the ETJ or the unincorporated area of the county. Regarding the plan approval, we do have some bond rules that would allow us to deny costs if the MUD didn't receive the necessary approval from the county. As we did find that, as stated in our response, that the Chapter 55 did did allow for the county to have standing on this matter, and that's regarding the roads, and that's the direction that we've been given from the commission in the past. But with that said, we are open to new direction.
Right. I think I've had a little different take on it, because I think that our rules specifically require us to look at that and consider it, but I don't think that our rules necessarily require us to grant based on that. It's just a consideration. And what I'm trying to understand here is at the end of the SOA process, does anything change? Are we going through this process without a justiciable issue at the end?
Again, we have found that they have had, based on previous commission direction, we have found that the county does have standing, and if we are,
I understand that's your position on it, but
right.
and I understand past commissions have found it that way. What I'm specifically trying to understand is, at the end of this process, is there a justiciable issue?
I'm not sure if I have an answer for you on that, Commissioner.
Okay, that's fine. I don't, I'm not trying to be antagonistic to you, so.
No, I understand. Justin Tack is here with me from the district section. He might want to weigh in.
Oh, sure. Love to hear from Justin.
Good morning, Chairwoman, Commissioners, General Counsel, Public Interest Counsel. For the record, I'm Justin Tack of the Water Supply Division. To answer the question is, did things change in the end? Historically, when we've gone through these SOA processes, what you have is you have experts on both sides of the table that give their opinions. Ultimately, at the end, it has not changed what we saw originally as submitted. There's been some that have gone through that the commission before deemed it not enough, and we've denied those before. There's been a couple, but historically, as we've gone through the SOA process, the figures regarding feasibility and the ultimate layout of the district and things like that have not changed from when the application was submitted to us.
Thank you, Justin. Katarina?
Justin, could you just quickly give us all of the, not all of it, like the high points of the things that you look at when you're doing a district creation?
Absolutely. So 54021 of the Water Code specifies our findings. In that, it says it also outlays the things we shall consider. So I'd argue decades ago, we adopted rules that incorporate the things and the items that are required to be submitted to us. Those things, as far as the rules concerned, the statutory things, the items that we are to consider are typically held within an engineering report that's signed and sealed by an engineer to discuss ultimate impacts to, in this case, we have drainage being one. Roads are handled outside of a different area of the Water Code and our rules, and they don't require any sort of a requirement to maintain those facilities. It's simply a layout of those roads. So the engineering report will go into great detail with all matters: feasibility, tax base, tax rates, overall costs, overall layout, how the district intends to receive water and wastewater, how it intends to handle things like 100-year flood events, drainage, those things. And typically, I'd argue almost all the time, all the reports, and at least when we adopt our memos, we specify that creating this district does not get them out of any entity having jurisdiction review authority. So they will be required to follow city, in this case, Williamson County standards, if applicable.
Thanks, Justin.
Yes, ma'am.
Commissioner Janaka? No. Kayla, what are we deciding at this phase right now?
If Williamson County is an affected person, but if y'all are going to grant or deny their hearing request to go to SOA.
That's merely the issue we have before the commission at this point.
Yes.
All right. Well, let's land this plane and talk to OPIC. Jessica?
Good morning, Chairwoman and Commissioners. Jessica Anderson for the Office of Public Interest Counsel.
Any questions for Jessica?
I don't have any. Thank you.
Bobby? No? All right. Well, I know that TCEQ's authority to create MUDs has caused some waves at the legislature lately and is in the news a little bit, but I believe that this is something that the legislature is going to look at the interim, and I am happy to have a work session on MUDs and the creation and any policy issues we need to work out. But here, the question that we have before us is whether Williamson County is an affected party. For district creation matters, we look to whether the hearing requester is entitled to a hearing. To recap my position from the previous agenda, as I see it, TCEQ rules require the commission to consider for governmental entities their statutory authority over or interest in the issues relevant in the application. I believe the county met this requirement with the statutory authority related to the building and setback and infrastructure planning, which can impact the density of subdivisions and ultimately the financial feasibility of the district and the drainage issues related to roads that it raised. Runoff and drainage are issues that the commission is charged with reviewing in the district creation petition. The county's request is also raises concerns about roads in the proposed district connected to the county's broad authority over various aspects of roads. The request for road powers in the application requires the commission to consider the layout of road facilities, the petitioner's cost analysis, and the amount of bonds necessary for the road facilities, and whether they are financially and economically feasible for the district. Therefore, I agree with the ED and OPIC's recommendations that Williamson County is an affected person, and in this matter should be referred to SOA. I also recommend that this matter be referred to the commissioner's ADR program to run concurrently with the SOA scheduling process. I'll pause here. Colleagues?
Thank you, Chairwoman. I appreciate your description of your analysis of the matter. I'm in agreement. I think our the current statutes and our current rules would obligate us to find Williamson County to be a party and for this matter to proceed in the way you described.
Thank you, Commissioner Janeka. Commissioner Gonzalez? Oh, Commissioner Gonzalez, we can't hear you.
Nothing.
Hold 1 second, Katarina, this is really important. Can someone please try to figure this out?
Can you hear me?
Yes,
Yeah.
Katarina, go ahead. Thank
Okay,
you.
Great, thank you. A question for the chair. By setting this with the ADR program, are you recommending that we set a maximum hearing duration?
Yes, I believe we'll do 180 days.
I think to be consistent, we would not set a
Oh, we
maximum
wouldn't.
hearing duration
Okay.
on this particular one.
Mary?
I think in the past we haven't done that, but I would be willing to support it if we did that in the future. I feel that really we're not having a justiciable issue on these, and these taking 2 years is really ultimately just costing the homeowners money and taxpayers money.
Commissioner Janeka, would you be willing to agree to 180 days?
I am willing to, with the little grousing that I've been sensitive to how pressed SOA's schedule already presses upon administrative law judges who are great experts in our agency, but become so through repetition, and I think are more prone to poor decision or rushing to a misinterpretation of our rules if they're under a compressed time rate. So I'm willing to support it. And in this matter, I'm sensitive to what might result in some feedback from SOA about how our exercising our ability to do so. We're not obligated to put them in a bind, but sensitive to that concern. Appreciate Commissioner Gonzalez for raising it.
Commissioner Gonzalez, any other thoughts?
I do think also that when we send these over to SOA for an indefinite amount of time and they take multiple years, that also ties up our staff. That, you know, I think the district's division, you know, generally does a good job, but if they're working on endless SOA matters that are, you know, taking 2 years, I think that's a problem as well. I would be willing to support this with a maximum hearing duration of 180 days in this specific instance.
Kayla, the 108 duration, what is your opinion or thoughts?
There is no requirement for these types of applications to meet a deadline. So we would defer to y'all on that.
Garrett,
Chairwoman, I would echo that. You know, this is a non-709 matter, so there's no required max of 180 days. So I do think it's up to y'all in this instance.
Commissioner Gonzalez, I understand where you're coming from. This is a policy issue we really need to look at in depth, but 180 days is a very compressed timeline for this issue. I would move that we would not have a deadline on this.
That has my vote.
All right. Do I have a motion?
I move that we grant the hearing request of Williamson County, refer the matter to SOA for contested case hearing on the petition, and refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process.
All those in favor?
Aye.
Oh, I need a second.
Would you like to second?
I second. All those in favor?
Aye.
All those opposed?
No,
We saw you, Katarina. Thank you.
thank you.
The motion passes. Thank you. Thank you all very much. Sorry about the tech glitches.
Are y'all able to hear me now?
We can hear you now.
Okay, great. Thank you.
All right, let's move on to new business.
New business 1. Oh, I'm actually going to give everybody a chance to move. New business 1 is the consideration of the restated petition for inquiry filed by Cockrell Investment Partners LP seeking a review of the Middle Pecos Groundwater Conservation District. The commission will begin with the petitioner, Cockrell Investment Partners, followed by the Middle Pecos Conservation District, then other response filing districts, any interested persons, the ED, and finally OPIC. The parties have been notified that they will each have 5 minutes of oral argument time. The petitioner may save some time for rebuttal as it bears the burden of proof on this petition. With that, we'll begin with the petitioner, and I believe we have Ryan Reed here to represent them.
Good morning. Thank you very much. I would like to reserve a minute of my time for rebuttal, please, or about a minute. Good morning. My name is Ryan Reed, and I represent Cockrell Investment Partners, the owner of Belding Farms. Belding Farms is a 70,000 plus pecan tree orchard in Fort Stockton, Texas, and it's also the 2025 Texas Environmental Excellence Award winner for agriculture for its efforts on irrigation and water conservation. Having farmed in the Texas desert for nearly 6 decades, Cockrell's engineering-minded approach, which it supports at UT, carries to its stewardship of the natural resources, and especially water. Belding Farms has made substantial voluntary investments in water conservation, which benefits all users using the Edwards Trinity Aquifer. I am joined by Cockrell's team of advisors, Zachary Swick, the farm manager, Jeff Pike, senior advisor to Cockrell, Carlos Rubenstein, and Andy Sampson. Anyone paying attention knows that Texas is facing a water crisis. Water is an issue of statewide importance, and it's affected by the adequacy of the rules of all groundwater conservation districts. Today, we ask the TCEQ to conduct a substantive review, not an administrative review, of the Middle Pecos Groundwater Conservation District's rules. Section 36.3011 of the Texas Water Code empowers the TCEQ to conduct this review, and without it, each groundwater conservation district throughout the state could implement toothless rules. This is the only way that Cockrell has found to ensure that the rules are adequate. The question Cockrell asked is, do the Middle Pecos's rules adequately achieve the desired future conditions and protect the aquifer? Set forth in our petition for inquiry, the answer is no. Only the TCEQ has the power to investigate, consider the evidence, and to make this substantive determination to bring certainty to the water planning process. What's set out in our petition and the numerous responses delves into a very complex issue, which is confused by special permit conditions. It deserves an impartial and an evidentiary review to ensure that these issues are understood and the aquifer is properly protected. A proper review will ensure that we don't create a new Vista Ridge situation. We should not be relying on emergency powers that lack details in terms of thresholds and curtailment. The responses are full of misunderstandings, anecdotes, and models that are not a substitute for sound science. Anyone who uses the Edwards Trinity Aquifer, whether it's Midland, San Angelo, or Abilene, who plan to buy water, or Fort Stockton, should share our concern. For nearly a decade, we have worked with the Middle Pecos, as well as other stakeholders, but at this point, we've exhausted those efforts, and we bring this matter to the TCEQ. We ask the TCEQ to exercise its powers under the Water Code. Please grant the petition, appoint a panel, investigate the rules to ensure that they achieve the DFCs and to ensure they protect the aquifer, and follow the science. With that, I'd like to invite the farm manager, Zach Swick, for a few brief comments.
Good morning to you all. That's loud. My name is Zachary Swick. I am a humble farmer. I do not belong or fit in this setting. I feel at home in the field, but I've left the field to bring you a message. The rules that are set forth that establish what we have at stake, what I'm really trying to say, sorry, let me start over. Without rules that establish meaningful, and that's really the difference between our two sides, meaningful thresholds and cutbacks, the Edwards Trinity Aquifer is at risk. The farm that I labor and the community that I love
4 minutes.
depend on this aquifer. Therefore, it must be managed responsibly with rules that are transparent and functional. Our community relies on this aquifer not only for agriculture, but also it relies on it for our local business, most small and large, and our drinking water. This aquifer supports not only the economy of our community, but also the very people of Fort Stockton. Therefore, our community deserves a substantive review of the MPGCD's rules. Additionally, the communities of and the residents of Abilene, Midland, and San Angelo, who ultimately will be the ones who have to pay for this water transfer, deserve a substantive review of the MPGDC rules. At the end of the day, we all want the same thing. We want this water to be there now and in the future. For the sake of West Texas, for the sake of Pecos County, my community of Fort Stockton, the men and women that I work with, my children, and my home, I want there to be a future. Thank you.
That's time.
Thank you very much. Michael, with Middle Pecos GCD. Good morning.
Chairwoman Pop, Commissioners Gonzalez and Janeco. Mike Gershon with the law firm of Lloyd Gosselin. I'm here on behalf of the Middle Pecos Groundwater Conservation District. Also here with me in person are our board vice president, Professor Janet Groth, and our general manager, Ty Edwards. It is rare that the commission is presented with this type of petition. The applicable inquiry statute and TCQ's implementing rule were enacted to create a mechanism to assure accountability by groundwater districts. Accountability for what? Accountability to ensure that they have in place rules, that they're carrying out their statutory mandate to have rules in place. Cockrell requests that you look at 3 of the 9 statutory mandates listed in your rules in the statute. Those 3 mandates require that those rules be in place and they be designed to protect local groundwater resources. Now, the applicable standard of review today, and it set forth in your rules and in the statute, is that simple. Whether rules are in place that are designed to protect local groundwater resources. The proof of Middle Pecos's compliance with the statutory mandate is obvious. It's obvious from the record before you. On file are over 40 exhibits, nearly 2,000 pages of our rules, rules that date back to initial rules over 2 decades ago, as well as the current rules in place that reflect an evolution and an enhancement of our regulatory program over those 2 decades. Also are studies, studies performed by licensed geoscientists and engineers, presentations, sworn affidavit, a board resolution that reinforce that regulatory program and those 3, the rules that achieve the 3 statutory mandates. This information underscores, reflects how robust the district's rules and regulatory program are. We appreciate your executive directors and your Public Interest Council's thorough written analysis and their ultimate assessment confirming that Middle Pecos does have those rules in place, does meet that statutory mandate. Cockrell cannot and does not come close to meeting the burden. When you distill Cockrell's petition, it's apparent they're not really challenging whether Middle Pecos has rules in place. There is a backstory. Mr. Reed hinted at what that backstory is to the petition. Cockrell is concerned about the groundwater export project that he mentioned. The project involving Midland, Abilene, San Angelo, Fort Stockton Holdings, Clayton Williams Farms. Cockrell wants Middle Pecos to change its existing rules that are in place to be more restrictive on that project. It is a misread of the inquiry statute, 363011, for Cockrell to attempt to affect local permitting that has occurred and policy decisions that have occurred through your office. There are other legal remedies in the statutes for Cockrell to protect its interests. Most importantly, Cockrell's ability to protest the underlying applications that were heard over a decade ago. The remedies under the inquiry statute are worth taking a look at. Ultimately, the commission has the right to dissolve Middle Pecos, dissolve its board and call a new election, appoint a receiver, or enter an enforcement-like order. Those remedies make it clear of the legislature's intent to allow TCQ to address situations where a district has been woefully negligent in not having an adequate regulatory program in place designed to protect DFCs and local resources. The inquiry process is not designed to target districts that have robust rules. And let's talk about the rules. They were developed with substantial public input over the years by many stakeholders based on extensive scientific research, expert opinions. Those rules have evolved and been enhanced over the last 20 years. The district is well funded. The rules were implemented by a board that meets at least once a month and by a staff and team of experts with a depth of experience as reflected in our nearly 2,000-page response. To grant the petition would be wasteful of your commission's resources, the resources of many other public entities that have provided responses to you, to Middle Pecos, to the cities. If I
Go
may
ahead.
close?
Finish, please.
Yes. Middle Pecos takes pride in its commitment to responsible stewardship. Cockrell's petition falls short of the applicable standard and the burden in your rules. We appreciate your consideration. We believe the record is clear and replete with evidence that Cockrell hasn't met its burden. Thank you for your consideration.
Thank you, Mr. Gershon. The petitioner used up all his time, but I am feeling very, very nice today. So I'm going to give the petitioner a minute to respond and also give Mr. Gershon a minute as well.
Would you like him to have his minute now, and then we can go to the other parties and ED info?
Thank you, Chairwoman. I've closed. If the commissioners have questions, I'd be glad to answer them.
Any questions? Katarina, any questions for Mr. Gershon?
I don't have any. Thank you.
Thank you. Right, Mr. Reed?
Oh, no, we actually have an interested party signed in to address the commission, and then we'll go ED and OPIC before we get to the rebuttal. But we have Mr. Ed McCarthy for Fort Stockton Holdings, I believe.
Perfect, thank you. I need to put on my glasses.
Good morning, Chairman Pop, Commissioners. My name is Ed McCarthy. Excuse me, I'm here on behalf of Fort Stockton Holdings LP. Fort Stockton Holdings is one of the largest, if not the largest, permit holder within the district, and is here in support of the district and to ask you to deny the petition. The petitioner has failed to meet its standards or criteria for securing the granting of the petition. This district has a very robust set of rules. The district has a very robust set of activities to protect the district, and this commission would be aware of those in part because of a series of rules the commission was considering a couple of months ago to implement statutory legislation on funding for orphaned wells and protection of groundwater that was passed by the past legislature, and the current session is looking at additional funding to support that. This district has been very aggressive in protecting groundwater. It has a very aggressive set of rules with triggers that have not been reached, triggers that have not been demonstrated to be inadequate. The district is doing its job. As Mr. Gershon said, the commission would be wasting its resources and that of all the parties at this time if it were to grant the petition. So I'm going to cut my remarks short and ask you to deny the petition and recognize this is a district that is doing its job and doing it well. I thank you. I'd be happy to answer any questions.
Any questions, commissioners?
No.
Thank you.
And the ED?
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. I am Kayla Murray, an attorney in the Environmental Law Division. With me is Eric Simon from the Water Availability Division, and we are representing the Executive Director. We have reviewed the petition for inquiry submitted by Cockrell Investment Partners, as well as the response filed by Middle Pecos GCD and additional responses from other GCDs. The petitioner alleges that the groundwater in GMAs 3 and 7 is not adequately protected because Middle Pecos failed to adopt rules designed to achieve its desired future conditions, and failed to enforce substantial compliance with its rules. Texas Water Code Section 36.3011 allows a landowner within a groundwater management area to request that the commission investigate a district's compliance with certain duties. The commission may then either dismiss the petition or appoint a review panel to conduct an inquiry. The ED finds that Middle Pecos has demonstrated that it adopted rules, that those rules are designed to achieve its DFCs, and that they adequately protect groundwater in GMAs 3 and 7. Therefore, the Executive Director finds that Middle Pecos is in compliance with the applicable Texas Water Code statutes, and the ED respectfully recommends that the commission deny the petition. Thank you.
Thank you, Kayla. OPIC?
Thank you, Chairwoman. Good morning, Commissioners, General Counsel, ED's attorney and staff. I'm Josiah Mercer with the Office of Public Interest Counsel for the record. We reviewed the restated petition and all the responses, including the response and exhibits from the district itself, and we also recommend dismissal of the petition. The district's management plan, as approved by the Texas Water Development Board, considers all factors required to be considered under the Texas Water Code, including routine monitoring of groundwater elevations. Additionally, the district rules demand aquifer level-based production limits reset annually to prevent the lowering of groundwater levels. Even the Fort Stockton Holding Settlement Agreement and export permit that is the subject of so much of the petition contains similar groundwater level-based limitations. Petitioner does provide information to show that if Fort Stockton Holdings and all other groundwater users use their maximum allotment, this could, over time, lower the aquifer. However, the district presents convincing evidence that these groundwater level-based production limits contained in their rules and management plan are adequately protective of groundwater levels and are consistent with properly established desired future conditions. OPIC therefore concludes that the district has properly adopted rules and that these rules are adequately protective of groundwater levels and will properly ensure desired future conditions are met. We find that the petitioner did not present sufficient evidence to show the existence of any of the conditions laid out in Texas Water Code section 36.3011B, and the petition should therefore be dismissed under Texas Water Code section 36.3011C. Thank you.
Thank you, OPIC. All right, I jumped the gun earlier. Mr. Reed, you have a minute for rebuttal.
Thank you very much for the extra minute. 5 points I want to make. First, the discussion here today has been an administrative review. There has not been any delving into the science to ensure that these rules are protective of the aquifer. Specifically, if you look at the district rules 10.2 and 10.3 on production-based limits, it is a may, and there are no standards set forth in the rule for what the thresholds are or when curtailments happen. Folks who live in San Antonio or Austin know when aquifers get to a certain level, there are cutbacks on how you water your lawn. There's no such thing in the rules or the special permit conditions at issue here. You heard a brief discussion about the West Texas Water Project involving the 3 cities. That project will produce 20 to 30,000 acre feet more of water than we have seen in the last 20 to 30 years out of this region. A project of that size, when you have rules that don't adequately set forth thresholds and curtailment standards, is deserving of the TCEQ's resources. The people of 4 very large cities in West Texas deserve a review by this commission and the resources to ensure. Thank you very much.
Thank you. Mr. Gershon, you have a minute?
Thank you, Chairwoman. Obviously, we beg to differ on Mr. Reed's and Cockrell's position. We respect their care for stewardship of the aquifer. That's our goal. That's our statutory mandate. We believe that the rules that Mr. Reed has cited to in section 10 of our rules, they incorporate by reference the detailed thresholds of our desired future conditions. We know at the district that we are statutorily mandated to achieve desired future conditions. Those rules are designed to do so. We have one of the most extensive well monitoring programs, networks, including transducers and SCADA type equipment, where we're monitoring levels daily, weekly, at monthly board meetings. We're workshopping and evaluating trends in aquifer levels. Those rules are designed to provide for that iterative process over time, and as pumping were to begin, to achieve those DFCs. So we beg to differ, and we believe that the program is in place. Thank you for your time.
Thank you very much. Appreciate y'all. Appreciate everyone's responses to this. Putting my water hat back on, it feels really good. Water is the most pressing issue facing the state. Water is the new oil in the state of Texas, and I expect it to become much more litigious as it becomes scarcer. Colleagues, the commission does not have significant oversight over groundwater conservation districts' management decisions. However, an affected party may file a petition for inquiry with the commission for a review of 9 reasons. The commission has 2 options in this matter. The commission may dismiss the petition if the commission finds that the evidence is not adequate to show that any of the alleged statutory conditions exist. If the commission does not dismiss the petition, then the commission must appoint a review panel to review the petition's allegations. Historically, the commission has appointed a review panel only when a GCD has not been performing its responsibilities and not in situations regarding disagreements in decisions. While the petitioner has standing as an affected person and the restated position meets the minimum content and notice requirements, I would dismiss the restated position. We can easily dispense with the petition's first allegation that the district failed to adopt rules, as the district adopted initial procedural rules effective in 2004 and has amended its rules several times over the past 20 years. I believe that the restated petition's real complaint is that the district failed to adopt the petitioner's suggested rule changes, which is a rulemaking process that cannot be reviewed by this commission. Furthermore, the district, other districts, ED, and OPIC responses demonstrate that the district's rules indicate a regulatory framework that appears designed to protect groundwater within the district and the desired future conditions in GMAs 3 and 7. I believe that the petitioner is primarily concerned with Fort Stockton Holdings export permit rather than the district's rules, but I do not see that the petitioner has shown that the permit conditions are currently affecting groundwater levels in the area. I'd also highlight that all the other groundwater conservation districts and other parties that responded to the restated petition support the district's regulatory program. I will pause there and see what my colleagues think. Commissioner Gonzalez. You're muted again. I'll go to Commissioner Ginecca.
Thank you, Chairwoman. I'm in agreement with your position as you described it. I appreciate that. I think as I review the underlying statute and our rules, this sort of a request could rise to that threshold where perhaps our agency could find that the rules as implemented were not adequately protective, but recognized to date. We have only utilized this authority where groundwater districts have failed to act whatsoever. And I think I would reiterate the point that you note where all of the surrounding districts expressed their support. And until I see that concern echoed from some of those factors called out specifically in this rule, I think it's a hard threshold for us to find has been met in this instance. But I do appreciate that that need for that conversation. I look forward to that discussion, hearing from the petitioner that in their view, our agency is the only avenue for relief in addressing an inadequacy of the level of protectiveness that our groundwater districts have taken. I take that very sincerely because we have chosen as a state, we've elected to leave that management in the hands of the lowest level possible. Those Texans closest to where they're directly infected by the use of their water beneath them. And I want to respect that, but where there is no clear avenue for those members of the public within those groundwater districts served by those districts to come seek relief in seeking change, I think we look obviously to the legislature and we look to this opportunity for relief. And it's an important discussion. If our rules, well, I don't see how our rules can get more precise than the statute. So I think that's an important place where, in my view, looking at it from the vantage point of one of the decision makers on the commission, I think we're not quite at that threshold, but I appreciate this. I appreciate this discussion. We're a very important issue.
Commissioner Gonzalez.
I'm in agreement with both of your positions on this.
I can't hear you.
We can't hear you, but I think what we might suggest, we might try to get you on the telephone because we still can see you, and we'll put the telephone next to the microphone and see if we can get a workaround that way. I feel like I can actually hear you, but it's very, very low.
Yeah, I'm not sure what's going on. I'm unmuted on my end.
Yeah, we can hear you, but it's too low for us to be able to really hear you well. So would you like to recess the meeting for a moment while we get this sorted out?
Can we recess for 5 minutes, please?
Yes.
Sorry.
Hello? Hello?
We're going to go ahead and get started. I think we figured out our tech issues or Band-Aid it up. I'm not entirely sure, but Katarina's on the phone.
Petition for inquiry against Middle Pecos Groundwater Conservation District.
Do I have a second?
I second that motion.
All those in favor say aye.
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 Motion passes. Thank you. Thank y'all very much. We'll give y'all a second to move.
Item number 2 is the consideration of the joinder petition filed by Restore the Grasslands LLC for the creation of Collin County Municipal Utility District Number 7. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record. As a courtesy to members of the legislature, the commission allows staff to read a legislator's letter to the commission. And I understand that we have Mr. Lane from Representative Noble's office here who's requested to make such an address. As a reminder to the commission, your decision today must be based only on the timely comments, hearing requests, requests for reconsideration, responses, replies, response to comments, application, and draft permit. Thanks.
Go ahead. Welcome.
Thank you, members of the commission. My name is Robert Lane. I'm Representative Noble's District Director, and I have prepared remarks to read. Dear members of the commission, as State Representative for House District 89, I have heard from hundreds of constituents who would be neighbors to this new proposed community. My constituents are universally opposed to this development. In fact, I have not heard from one constituent that supports the plan that is put forth by this development. As a result, I join my voice with the cities of Parker and Murphy, the two cities that will be very negatively impacted by this project, to oppose this specific development. We are by no means anti-development. We have numerous developments in progress in the vicinity, and this proposal is no different. And this proposal is so different and so outside the norm of the area that it has caused great concern as to the effect it will have on both the current residents and the future ones that will be impacted by this outlier. Since this proposed development began, we have had a difficult time trying to determine the true owner of the property and who is the actual developer and applicant for the build. As a result, we have not had the opportunity to vet the source of the information that was provided on the application. Many of the proposed findings on the original application were not only misleading, it gave your body a completely inaccurate picture of what you have been asked to approve. In regards to the application, all process should be followed in the most transparent and open manner possible. The application from start to finish should be required to list the current owners and holding entity, which up to this point it has not. The Restored the Grasslands LLC did not start this application, nor have they updated, to my knowledge, the inaccuracies that they were included in their original TCEQ application. As a result, I do not believe the application that you have before your commission should progress. And it is our understanding that some of the adjustments that have been made during the over 4-year process have actually been contrary to some of the original application assertions. Therefore, I formally request a contested hearing of the formation of the Collin County MUD number 7. I thank you for hearing our concerns.
Thank you very much. Appreciate you. All right, before us, we have a petition to create Collin County Municipal Utility District number 7. This item first came to the commission at the July 20th, 2022 agenda, and the commission decided to refer a number of hearing requestors to SOA for a contested case hearing. I would not disturb the commission's previous determination on the requestors it considered in 2022, so I would re-grant those requestors that the commission originally determined were affected persons at that point. Colleagues, your thoughts?
Well said. Nothing to add.
I see it the same way.
Let's move on to the new hearing request we've received on this item. Since the commission first considered this item in 2022, the petitioner filed a joinder petition and published a new notice of the district petition. This provided an additional opportunity for interested persons to file comments and request a contested case hearing on the district creation petition. The commission has received numerous hearing requests since the original hearing request deadline. After reviewing these requests, I've identified numerous requestors who reside in the close proximity of the proposed district and identified personal justiciable interests, such as concerns regarding drainage and runoff from the district impacting flooding on their property. I have a document to distribute that lists the hearing requestors that I would find to be an affected persons in this matter. It contains those that were granted in the first time around and those that I just discussed. I'll ask General Counsel to distribute the list to the parties and to Commissioner Gonzalez virtually and to Commissioner Janeka in person. And let's take a 5-minute recess to review the list and see if we're all on the same page. Thank you. All right, has everyone had time to review the list?
I have done so, and I'm in agreement with that list of names and I'm ready to move forward.
Commissioner Gonzalez? Commissioner Gonzalez, have you had a chance to review the list?
Yes, I'm good with the list.
Wonderful. Thank you so much.
Thank you.
I'd also note that I recommend denying the remaining hearing requesters that are not listed in the document and recommend that we deny all requests for reconsideration. Do I have a motion?
I would move that we grant the hearing requests of those listed in the document that was circulated at the dais today, that we deny all remaining hearing requests and requests for reconsideration and refer the matter to SOA for a contested case hearing on the petition.
Do I have a second?
I second.
All those in favor say aye.
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 Thank you. The motion passes. All right, thank y'all very much. Let's go to item 3.
Item number 3 is the application by the City of Venus for renewal of TIPD's permit number WQ 00108883002. The parties have been notified that the commissioners will not take oral argument, but may ask questions. And those who have signed in will be noted for the record. As a courtesy to members of the legislature, the commission allows member staff to read a legislator's letter to the commission. And I understand that we have, oh, I'm sorry, wrong. I'm on the wrong item. So we can cancel all of that. This item is before you for consideration.
Thank you. The item before us is an application for a TIPD's permit renewal. We have both hearing requests and requests for reconsideration before us. Colleagues, one of the issues raised is the timely request for reconsideration by Robin Farrell caught my eye. So I'd like to turn to those requests first. In her request for reconsideration, Robin Farrell states that the application includes a new discharge point location and asserts that the application should have been processed as a major amendment instead of a renewal without changes. She states that a major amendment would have prompted landowner notification to landowners who are newly included within the 1 mile of the revised discharge point. I reviewed the agenda backup and I see that the executive director's technical memo points out a change from the existing permit, specifically that the discharge route has been updated in the draft permit to include an unnamed tributary. The permit renewal application also indicates a change in the outfall location. These changes raise a question for me about whether the application should have been processed as a renewal with the major amendment. The executive director's response to comments in this matter indicates that a major amendment application would require mailed notice to landowners named in the application map. Because of this uncertainty, I would grant Robin Farrell's request for reconsideration and remand this application to the executive director for reconsideration, including consideration of whether we are dealing with a major amendment that will require the agency to renotice the application under chapters 305 and chapters 39 of our rules. I understand that there are hearing requests and requests to extend the hearing requests and reconsideration request deadlines that are also before us today. I would recommend that we reserve our consideration of these requests until the matter is brought before us again after the ED's reconsideration. After reconsideration of the application, the ED may notify the Office of the Chief Clerk when the matter is ready for docketing on a future commission agenda. Colleagues?
I think the same way. I would appreciate hearing from the executive director on their analysis of whether this reached a major amendment threshold and therefore obligated further notice of the parties than was undertaken so far, which that's a very important distinction. And I can attest to having spent 5 years in the ranks of the permitting staff of our agency, how much that's drilled into us, the very serious importance of the increasing tiers of rigor of our agency's analysis and the public, the obligation to notify the public and provide them an opportunity to engage as we reach higher levels of that process that we undertake. So I think it would be appropriate to take a full look at that before we instead send it on at this time.
Thank you. Well said. Commissioner Gonzalez,
I'm in agreement as well. Thank you.
do I have a motion?
Yes, I can make that motion. I move that we grant the request for reconsideration filed by Robin Farrell, remand the application to the ED for further evaluation and additional public notice as necessary, and reserve the commission's consideration of all hearing requests pending the ED's reconsideration of the application.
Do I have a second?
I second that motion.
All those in favor say aye.
Aye.
Thank you. The motion passes. We are on item number 4.
Item number 4 is the application by Gonzalez Brothers Batch Plant LP for issuance of air quality standard permit for concrete batch plant, registration number 174578. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Well, good morning. For this item, the applicant has applied to TCEQ for registration under the standard permit for a concrete batch plant. Texas Health and Safety Code sections 382.058 states that only persons actually residing in a permanent residence within 440 yards of the proposed plant may request a hearing as a person who may be affected. The commission received multiple hearing requests from Cassie and Patrick Coburn. The application map indicates that these requesters' residence is more than 440 yards from the nearest admissions point. Thus, I believe we are compelled to deny their hearing requests. Colleagues?
I appreciate it. I see it the same way. The close lines and close statutory areas of review on this item loomed large in my mind. And I think, in my view, the fact that the requesting parties did not continue to respond to the allegation or the concern that there's a building within the 440 yards, that, in my view, suggests the record strongly supports a denial and issuing that permit today.
Katarina?
I'm in agreement.
We also have a timely request for reconsideration. This request raises issues that are not within the Commission's jurisdiction or raise general air quality concerns that are addressed to my satisfaction in the ED's response to comments. Therefore, I would deny the request for reconsideration.
I agree.
Katarina?
I agree as well.
Finally, I'd issue the authorization to adopt the ED's response to comments.
I could make that motion.
Thank you.
I move that we deny all hearing requests and requests for reconsideration, that we issue air quality standard permit for concrete batch plant registration number 174578 to Gonzalez Brothers Batch Plant LP as recommended by the executive director, and that we adopt the executive director's response to comments.
Do I have a second?
I second.
All those in favor say aye.
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 Thank you. Moving on to item number 5, we'll give y'all a second.
Item number 5 is the application by Bar2 Ready Mix LLC for issuance of air quality standard permit for concrete batch plant registration number 176138. This is one that we have a Senate staffer here. As a courtesy to members of the legislature, the commission allows members' staff to read a legislator's letter to the commission. And I understand that we have Ms. Bowman from Senator Paxton's office here, who perhaps wants to read a letter, but if not, if I'm incorrect, no. Okay, I'm sorry. Again, this item is before you're committed, before you for your consideration.
Wonderful, thank you. This application is also for the issuance of a registration under the standard permit for a concrete batch plant. We received 3 timely hearing requests on this item. As discussed in the previous item, for a concrete batch standard permit registration, there is a statutory requirement that an affected person must reside within 440 yards of the proposed plant to be referred to SOA for a contested case hearing. After evaluating all relevant filings, including the amended responses filed by the ED and OPIC, I did not find that any hearing requester satisfied that 440-yard requirement. Therefore, I deny all hearing requests. Colleagues?
As the record has been clarified, I agree with you and would find the same way today.
I'm in agreement as well.
Thank you. I would also deny the request for reconsideration for this matter. I'm satisfied that the ED fully and appropriately considered all relevant and material issues raised in the request for her response to comments. Commissioner?
Agreed.
Commissioner?
Also agreed.
Colleagues, any thoughts on the RFR? Nope. And with that, I would also adopt the ED's RTC and issue the permit. Commissioners?
I'm supportive.
Wonderful. Do I have a motion?
I move that we deny all hearing requests and requests for reconsideration, issue air quality standard permit for concrete batch plant registration number 176138 to Bar 2 Ready Mix as LLC as recommended by the executive director, and that we adopt the executive director's response to comments.
I second the motion.
All those in favor say aye.
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 The motion passes. Thank y'all. All right, we will head to the enforcement docket, items 6 through 34.
So as you noted, this is the enforcement docket, items 6 through 34. I will just note that at the ED's request, the Office of General Counsel continued item 24 until the June 23rd agenda. But the executive director staff is here to present these items.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Craig Pritzloff, Director of the Office of Compliance and Enforcement, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 6 through 23 and 25 through 34. The total assessed administrative penalties are $842,752, with $120,829 deferred, $348,009 applied towards supplemental environmental projects, and $373,914 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Wonderful. Any questions for Melissa? Is anyone here signed up on these items?
So on items 11 and 14, we have individuals who signed in and are available for questions, but haven't indicated that they wish to address the commission.
Do we have any questions on items number
11 and 14?
11 and 14?
No questions, but I appreciate you being available.
Okay. All right, OPIC?
Good morning, Chairwoman and Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC has reviewed each of these enforcement items, and we support adoption of all the orders presented by ED staff, except for continued item 24.
Excellent. Thank you, Garrett. Do I have a motion?
I move we adopt items 6 through 23 and 25 through 34 as recommended today by the Executive Director.
Is there a second?
I second.
All those in favor say aye.
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 Thank you. The motion passes.
Item 35 is the consideration of the monthly enforcement report, and the executive director's staff is here to present this item.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me are Craig Pritzloff, Director of the Office of Compliance and Enforcement, and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2025 through March. There were 598 effective administrative orders issued, and of those, 56 contain supplemental environmental projects. These orders assess a total of $8,095,009 with a payable amount of $5,220,093. $1,770,278 are to be paid toward supplemental environmental projects. 10,677 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 1,031 enforcement action referrals have been received. There are 3,163 pending administrative orders with 1,509 cases that are on the backlog. 139 cases are pending at the Attorney General's office for representation in district court, and 6 judgments have been issued. 1,469 cases are being tracked for compliance. We are available to answer any questions you may have.
Thank you so much. Any questions?
Not a question necessarily, but I do just observe that I think the tremendous effort that's being applied to address our caseload is reflected in a flat line in the number of backlogged orders right now. That, in my view, I think shows that we're a traditionally very high volume, unfortunately, shop in that regard. And the last 2 years of data show a clear upward trend that reversed mid 2024. And I think the flat line, though it may look like, why aren't things dropping on that number? I think that reflects a tremendous cycle of cases where that's a significant effort, keeping it flat. And the support there really is just how some of the other indicators, number of effective orders, number of notices of violation, are at or above previous years. And I want to commend staff for their effort. It's not hard to dig into the report to get the kudos on it, but I appreciate all the effort that goes on in this part of our agency.
Thank you, Bobby. Katarina?
No comments, just I appreciate everyone's work on this. Thank you.
Garrett?
Public has no comment except to say we appreciate staff support.
It's a very appreciative moment right now. I'd also like to thank staff for the report and the work that y'all do to ensure compliance. It's compliance first. I need my button. Thank you. Anything to add? Nope. Do I have oh, no, I don't have, no action is required on this item. So we will go to the next item. Yes.
Items 36, or the commission will meet in closed session in room CR 247 of the Texas Workforce Commission. Commissioner Gonzalez will join virtually at it's 11:09 now.
11:15.
At 11:15, as permitted by the Open Meetings Act, including Texas Government Code Sections 551.071 and 551.074, to take up and consider matters pursuant to items numbered 36 through 39 as posted and noticed.
This meeting stands at recess. Thank you.
The commission met in room CR 247 of the Texas Workforce Commission for closed session from 11:17 a.m. until 11:34 a.m. on item number 37 as posted in notice pursuant to Texas Government Code Section 551074. No action was taken. This agenda stands adjourned and the time is 11:47.